Welcome to the History, Law, and Justice Podcast. I'm your host, Michael Buckner, a lawyer and amateur historian. I will explore with you legal issues affecting governance, society, and culture of the United States and other civilizations, both past and present, using history as my guide. The global reach of the COVID-19 pandemic will eventually test the limits of each country's legal system, as victims and their lawyers seek a sense of justice in these uncertain times. Could victims in this pandemic have a legally sound lawsuit against professional and college sports leagues, restaurants, hotels, grocery stores, hospitals, cruise ship companies, and other service providers if it can be demonstrated that the virus was acquired while that person was present on the premises owned or operated by that business? Based on historical precedent from legal cases in the United States and other countries involving the SARS and H1N1 pandemics, as well as food and airborne disease outbreaks, the short answer is yes, provided 1. The plaintiff demonstrates he or she contracted the disease at a location owned or operated by that business. And 2, evidence exists that shows the risks were foreseeable, but the business did not take all reasonable measures to prevent the victim's exposure to the disease. Before proceeding further, in the scenarios discussed on this podcast, victims, when I mention victims, that could mean customers and clients, but also in the workers' compensation context, it could also mean employees. Okay, say a person has acquired the virus and that person has been damaged from that virus and wants to pursue a legal case against a service provider. What would that victim have to prove? What type of evidence would his or her lawyer have to acquire or collect? What type of analysis would a court of law and then a jury have to use in order to determine whether or not that service provider is liable? Well, first, the victim would have to establish the exact source of the illness. In past cases, for example, this was established with evidence indicating several persons became ill with the same disease within a definite period after lodging at a hotel or eating at a restaurant or attending a convention at a particular location. Think foodborne illnesses like hepatitis and airborne outbreaks like Legionnaire's disease. Those cases involved that type of analysis where people got sick at a particular location within a particular period of time, and the lawyers were able to establish that that victim or those series of victims acquired those particular diseases at those particular locations. After that's established, then the next step in analysis will look to see whether or not there were any foreseeable risks, which depend on the unique circumstances of each case. If the harm to a victim was foreseeable, and in this instance, the spread of the virus in this pandemic is definitely foreseeable, then the law requires a business to take whatever reasonable steps will minimize that risk. Simply at trial, a jury would ask, was it foreseeable that a customer might contract the virus at that business establishment at that particular time? The answer to the first question is yes. Then the next question is, did the business undertake reasonable measures and actions to make that risk less likely? Well, what would a business do to take all reasonable measures to decrease that risk, to make it less likely? In short, a business would have to show that it undertook a combination of various actions, decisions, and measures to limit the foreseeable risks for its customers, clients, and workers. For example, did the business carefully comply with the relevant government guidelines and directives, as well as strictly follow the advice of governmental authorities, including the CDC and local health departments? Did the business implement the recommendations of external consultants, internal auditors, and other experts contained in recent audit reports or studies? Did the business knowingly expose, especially in closed environments, workers or customers to people who potentially had the disease or did have the disease? Did the business implement scientific-based safety protocols? Did the business provide training on such measures? Did the business provide safety equipment to employees? And finally, did the business use other reasonable procedures to limit the exposure to the virus to its workers and customers? As we begin to open up businesses and other segments of our society, a service provider should engage in deliberate analysis before it decides to resume customer-facing operations. And for those businesses currently open, like grocery stores and other service providers, those businesses should constantly be reevaluating safety protocols based upon the latest and best data and information. Don't be that test case. Don't be that legal precedent that lawyers and courts are going to rely upon and cite for years to come. Get ahead of those lawsuits and use the best available science and common sense to make the right decision for your customers and employees. You're just listening to the History, Law, and Justice podcast with your host, Michael Buckner. Thank you for your attention. If you have any questions or feedback on this episode, Michael's contact information is included in the description box. Citations to sources used to prepare this episode are also listed in the description box. Finally, don't forget to click on the link to subscribe to receive the next episode of this podcast. Remember to let history serve as your roadmap for future success.